Good evening and welcome. We're delighted to have you join us today for our presentation on estate planning basics. Um, for those of you who are dipping your toe into this whole process and are considering preparing your will for the first time, we applaud you. I read one article that they found that people who prepared wills or estate plans tended to live longer than those who did not. Because they tend to take care of their affairs, keep their homes in order, take good care of their health. So well done. You just, as I tell donors, you just gave yourself 10 extra years of life. So we'll get started here. I will be presenting. Anne was going to field questions. Now on your screen, there should be on the bottom a scroll bar where you can ask questions. And Jen Jennings of our office, who I'll introduce at the end, will be fielding those questions. So please feel free to ask them. If we don't get to it at the end of the presentation, we will be sure to follow up with you. So we want to make this as useful to everyone as possible. So without much further ado, we'll get started. For today's lesson, as I like to say, the agenda is we're going to talk about, well, what is an estate? It means different things to different people, but we'll talk about all the things that go into an estate. Probate, that's a term you may have heard before but aren't familiar. We'll go into the mechanics of how that works, what probate does, what it does not, why it's important, things to think about. Wills and trusts. Trust is a term that you hear a lot. There are all kinds of different trusts. Is there an advantage to doing wills over trust and vice versa? And of course, other considerations. When you meet with an estate planning attorney to go over or to begin discussing possibilities for your estate plans, there's other things to take into consideration, which we will be sure to touch upon. So first and foremost, what exactly counts as an estate? And essentially, in kind of simplest terms, the estate is all of your stuff, as one donor once told me. It's everything that you own. So first and foremost, of course, real estate, your primary residence, any vacation homes that you might have in other states, if you will. Any kind of mechanical cars that you own, boats, tractors, all that comes under as part of your estate. Life insurance, if you have whole life paid up life insurance policy, even though you may have beneficiaries of that life insurance, the value of it may come into consideration for your estate in terms of your estate size. All of your bank accounts, if you have checking, savings, money markets, those are also part of your estate. Investment accounts, if you have any IRAs, 401ks, 403bs, those are also part of your estate. Any intellectual property, if you have any patents or trademarks that are certified to be and authenticated to be yours, that's part of royalties. All that comes into part of your estate. And finally, all the personal effects. Art, jewelry, clothing, household goods, everything you can kind of think of essentially is all part of your estate. And when you first meet with an estate planning attorney, they will typically have a questionnaire to help you figure out what you have. And how is property owned? And this is important, particularly when it comes to how estates get settled when you should pass away. Of course, when it comes to real estate and vehicles, intellectual property, there's deeds for real estate, titles to your vehicles that you may own, and of course certificates. If you have a patent, there's an actual what's called a certificate of authenticity to show that you actually own this. Account holders, if you have life insurance, bank accounts, investment accounts, those are all things that you do own. And then, of course, with possession, we talk about art, jewelry, clothing, and household good. Some possession exceptions, of course, rentals, provenance. This is in the very rare instances of perhaps there may be an artifact or a piece of art that somehow has been passed down to generations in your family, but now we're finding out, as it turns out, might have actually belonged to someone else. There was one instance, for example, we had some Native American artifacts that belonged to a certain tribe that had to be returned. So very rare, but these can come up from time to time. So what happens to all of this stuff when you should pass away? Well, for everything that you owned that we reviewed, all of that will be distributed through what's called the probate process that we'll get into shortly via a will, or last testament and will. Other types of property will pass through what's called the beneficiary designation process. For example, IRAs, or if you have 401ks or 403bs, we will all get those notices of have you updated your designation of beneficiary form. So whoever you have designated on that form, the administrators, such as Schwab or Edward Jones, whoever is administering your IRAs, for example, by law have to distribute that per what you have on that form, regardless of what you have in your will. And of course, rights of survivorship, that is in terms of real estate that you may be owner with others as well. Property owned by revocable trust. Revocable trust is another term you may have heard, also called living trust. And we'll do a bit of a deeper dive on that shortly. But of course, there are things that are in the trust get passed on per the instructions that you have put in the trust document. Trust did not go through probate, and we'll talk about that a little bit later. The same way, in some of these trusts that are set up, the living trust may have ownership of, say, an IRA, but at death, the IRA must be distributed per the beneficiary designation. Probate. So this is an important process and one that you may have heard. Perhaps some of you have served as executors of wills for family and are somewhat familiar. But essentially, the probate process is a process whereby your will, your instructions in your will are fulfilled as overseen by a probate judge. Every municipality has in their court a probate judge whose job is to make sure that the wishes outlined in a will or are administered and fulfilled. All gifts to charities, bequests, and they keep track on it. What I like to tell people, essentially, the probate judge is making sure that things are moving along, because no one wants to keep an estate unsettled because it has to pay taxes during that time, and heirs may be waiting to get their inheritances, any number of things. It's just better for everyone. So the probate judge makes sure things are being taken care of, taxes are paid, and the executor is held accountable and has to pay for that. Now, in some instances, and sadly, this is quite common. I read one study, a little over 50% of Americans do not even have wills. And in that particular, which is not a situation that is enviable, in that particular case, you will have deemed pass away intestate if you died without a will, at which point the state has essentially formulas or prescribed outlines of how estates should be settled. The court will appoint an estate manager who serves as executor. And of course, everything that had to be done anyway will still be done, such as taxes are being paid and filed. If property has to be sold to be distributed, all that has to be done. In some cases, people you might not necessarily want to inherit from your estate might, depending. So another reason why it's important to have a will, to make sure estate goes where you'd like for it to. And all the fees that are part of that process are deducted from the estate. And there are certain limits, of course. And even if you do have an executor, they have to report a very close accounting of the estate as it's being settled. And when they report, for example, when we get a bequest here at Mizzou, all charities from an estate, we have to sign what's called a receipt and release, which essentially says, yes, we received this wonderful, generous bequest from the such and such estate. The executor then reports that to the probate judge to prove that things are moving along. Now, wills, all about wills. In its simplest definition, a will is simply an instruction, a document that goes into effect when you pass away, and that you distribute your estate, all the things that we talked about earlier. If you pass away again without a will, you have died intestate, and the state determines. There are certain things that have to be met for a will to be valid, and for the most part, they're pretty inconsistent by state. I know we have guests from all over the country this evening. Again, an estate planning attorney will know what's required for in your respective state. But what we see across the board, of course, is called a valid testator. That's you, the person who signs this will, and how you want things administered and taken care of after you should pass away. We give specific instructions. This is, you sign this in front of two witnesses for proof that it's legitimate. Some states require what's called a self-proving form. It's optional in the state of Missouri. This is an additional form that essentially the ones I have seen that say, I am of sound mind, I sign this willingly, not under any kind of influence, to show that you are pressured into doing so should someone contest your estate, saying, well, they didn't know what they were doing when they signed this. And then a holographic will is not something off the USS Enterprise and Star Trek, but simply a holographic will is a handwritten will. And some states, very few accept them, and not allowed in the state of Missouri at all. So who are these people we talk about? Well, the testator, the person who signs the will, presumably you, if you're thinking about doing a will. For Missouri, it's to be over 18 and be of sound mind. The requirements for that are that you know who you are, you know who your relatives are. So the requirements are not particularly difficult to meet that standard. The executor is named in the will, oftentimes right at the beginning, where it says, I make this my last will and testament, and this is the person that you appoint to take care of your wishes that you've outlined in your will, and how you want that done. In some cases, might be giving property directly, so perhaps maybe jewelry, certain heirlooms to your loved ones, or you may instruct it to say, I want to have these things sold, the proceeds of which are distributed evenly amongst my children, or gifts to charity, what have you. So they are, it could be busy depending on the size and complexity of your estate. You know, if you have properties that need to be sold. So the executor is a person who is moving things along and, again, reporting to that probate judge. They also may set up certain what's called testamentary trusts. And we'll get into that a little bit further in the presentation. So what can a will do? Well, that's when you can instruct, if you have different types of property, how you want them to be, how the estate to be settled. Do you want those properties to be sold? Do you want some of them to be distributed? Wills are, there's no right or wrong. It's kind of, every situation is unique and different. I will tell you just from what people have shared with me. I've seen some estates where there are specific dollar bequests that go to loved ones and charities. And then if there's what's called the residue, everything is sold, and that residue is just, if there's anything left, is distributed. But again, you will, working with your estate planning attorney, they're going to talk to you and learn what's important to you, what you want to accomplish. And the nice thing about a will is that you can change it. And you probably will. The estate planning attorneys will tell you it's probably a good idea to check every 5 years. Maybe your executor has moved out of state. Maybe they predeceased you. There can be any number of different reasons to review your will. If you have minors or you have children, a will's a great place to outline who you want them to be their guardians, as well as if you want to set up what we call family trust to look out for them. And trust can be, there's all kinds of different trusts within wills that can be created. We call them testamentary trusts. You can also set up life estates. This has to do with real estate. There's any number of different ways you can pass on property to your loved ones and heirs. And as I mentioned before, it's an opportunity to make, it's a wonderful opportunity to make gifts to charities that are meaningful and important to you, to continue your values and continue your philanthropy in many instances. And again, this is for all the property that is held by the estate. Sometimes we get asked, can you put funeral directions? You can put them in there. Just make sure that your executor knows about it, because sometimes the wills haven't been found until after the funeral. That's something that's not uncommon. So That does pop up. What can a will not do? Well, for all the property that's in the estate, the instructions are there and it can be done, but for anything that's outside of it, it can't. So if you have some property held in we talked about a trust, a living trust that's handled differently. We talked about property passing by beneficiary designations. So for example, again, the IRA example, you may have your entire estate being distributed evenly amongst your children as an example. But if your IRA says it's going to my siblings, that's where it's going to go. Rights of survivorship, this has to do with if you own property jointly with others. And of course, beneficiary deeds, another way of transferring property that does not have to go through probate. And there's different reasons you may want to do that. The will does not go into effect until the testator has passed. No, this is a question that's come up. Can spouses be completely disinherited? And no. And again, in your particular situation, your estate planning attorney is going to walk you through it and go over all these things with you. Onwards to trusts. It's a term that you do hear a lot. The ones that we're focused on for this presentation is oftentimes what we call a living trust or revocable trust. And essentially the way it works, a trust is actually a legal entity when it's created. It has its own tax ID and yes, has to pay taxes. It's revocable because the person who creates it can change it at any time, but does become irrevocable once that person who created it passes away. Now, it has its own cast of characters. The grantor or trustor is the person who actually creates the trust. There's the trustee. This is the person responsible for filing the tax forms because it does have a tax ID. If there's any investments that need to be done, what have you. And then if there's an arrangement where there is income being paid to heirs or to beneficiaries, and that can all be the same person, by the way. It does not have to be three separate people, again, depending on what your circumstances are. Other thing about trust. Now, they are popular with estate planning. And why is that? And probably the two of the most common reasons that estate planning attorneys share with me is that when they avoid probate. We talked about earlier when you pass away and you have a will, you go for the probate judge, there's a period of time where that will is made public. And every once in a while we hear about it from the celebrities, of course, find out where their estate's going, what have you. There's also a period where during that time when people can come and contest the will and saying, where's my share? I can't believe they lived me out. And unfortunately, it can happen. But if you have what's called a living trust or revocable trust, it avoids probate altogether, meaning that it is not made public. And so the number one reason why people will set those up is to keep their affairs confidential. Now, it doesn't avoid estate taxes if that's a concern for your particular estate. And another nice thing about that as well with living trust is if you have property in more than one state and you have a will, you have to probate that will in each of those states where you have property. Not so if you have what's called a living trust, because everything is named within the trust. So another convenience or advantage to having a living trust. Within the trust document, we mentioned a grantor, the person who creates it. Oftentimes they are the trustee. They can have a successor trustee should they become incapacitated, who can step in even before the grantor passes away. It avoids probate, as I mentioned as well. And again, it becomes irrevocable when the grantor passes away. And in there, there'll be instructions on how the estate is to be administered or distributed. They can also create other trusts as well. So looking at kind of what's called the pros and cons, again, depending on the situation. Nice thing about, again, revocable trust, it avoids probate. Now, in some instances, there may be some assets outside of the trust. One common scenario is, oh goodness, that small savings account that we took out 40 years ago and you forgot about it. So a lot of times estate planning attorneys will create what's called a pour over will, where essentially this document says, hey, anything that might be outside the estate that we forgot about will be dumped into the living trust. And that way it can be administered and overseen in that regards. The successor trustee can step in if the grantor becomes incapacitated and is no longer able to administer if they're also serving as trustee of the trust. As I mentioned before, it's also private. And again, as long as the grantor is alive, they're responsible for the taxes until they should pass away. Then the trustee will have to handle it after that. Again, sort of a con, it does avoid probate. And in some instances, people would like to have an accountability to a judge. We hear about that sometimes as well. And when you set up a living trust or revocable trust, everything has to be named in it. So we looked at all the things of your estate, your car, your real estate, your accounts. They all have to be named within the trust, which can be expensive, at least up front initially. That's another thing to consider. And if there can be it can be formally amended, but that usually comes at a cost as well. So more things to think about. When you're meeting with an estate planning attorney to go over, they will also want to talk about other things you should be thinking about, one of which is power of attorney. You may have heard this, one of which is called a power of attorney for finances. So this is someone who can step in and make financial decisions for you or fulfill your fiduciary responsibilities should you become incapacitated or unable to. And there's different ones. They have springing and durable. It all depends on what kind of circumstance you want. But again, you're assigning someone to handle your affairs should you become unable to do so. And you do not need a formal guardianship to set that up. There's also what's called the power of attorney for healthcare. This is a document where you essentially assign someone to handle your medical affairs on your behalf. This perfectly complies with HIPAA regulations. And I've been told that in Missouri, the Missouri Bar website has a fillable form that you can do. You'll also hear about, sometimes attorneys will come up with mention about what's called a living will or advanced healthcare directive. This is where you may outline how you want it to be cared for, sort of end of life care. Same thing with pain management, and definitely some important decisions that you'd want to discuss with your power of attorney for healthcare, but it's also outlined there. Some hospitals require that you have one when you are admitted, depending, but it's a document that, again, an estate planning attorney can help you prepare as you're preparing all your documents. Choosing an executor and a trustee, this is a question that comes up. And of course, all of this that we're sharing are things that we've run into. We are not by any means dispensing any legal advice. The purpose of this presentation is just to touch upon some things to help familiarize you and help you with the process. So much of what we share is what our donors have shared with us. So, but choosing an executor or trustee, of course, you want to choose someone wisely. It does take time. Obviously, someone who may be nearby, because they have to report. They have to, once you pass away, there's a death certificate, and they will have to use that to perhaps close out accounts, set up new ones to pay, new accounts to pay your bills through the estate. So there's definitely a lot of work, and again, depending on the complexity of your estate, all the assets that you have, do you have properties that need to be sold? It's someone you want to think about, someone who's very well organized and who knows you well. Banks can serve as trustees is another thing to think about, but you want to find someone who you can trust. So some estates, they may name a successor executor, if the executor, the primary one, is unable to fulfill the responsibilities. Other things to think about, of course, if you have minors, if you have children, through your will, you can assign who will be guardian of your children. These are the people who will be responsible for rearing your children, helping them be raised, making decisions for them for schools, how they, summer activities and all of that. And so that's an important thing to be thinking about. You may want someone to handle the financial needs of your minors, who is separate. Some people, has been shared with us, they have two different people. Like, I trust this relative, my sister or my brother. great for the life decisions and passing my values. I think I prefer my other sibling to serve as the conservator, to invest and dispense all the financial needs as necessary through the lifetime of their child. So again, your will document how you want things to have set up. You may want to do a family trust that pays out an income to support your children, and at a certain age they can have access to it. There's any number of different ways. There's, again, no right or wrong way. It's whatever you're most comfortable with. So, and again, it doesn't have to be the same person for both. In some cases it is. And of course, lastly, before we get to the questions, including Mizzou in your estate plans. As I tell people, the perhaps the only guarantee we have in life is that day will come when our bodies physically expire, and yet I say people bet against that. They don't do a will, and it's a missed opportunity, and particularly for philanthropy, it's a wonderful way to make a gift. To support what's near and dear to you. The case for us is here at Mizzou. All the while, you can enjoy your assets and use them during your lifetime. So if estate taxes, and that may depend on your state, Missouri, there are no death taxes or estate. In Illinois, for example, there are. For states, I believe, 4 million above, there's a graduated death tax. When they look at the size of an estate, they would immediately deduct all charitable bequests from that. And so some people will use that opportunity to make gifts to support a number of their alma mater, Mizzou, and other nonprofits. So something to think about. The beneficiary of retirement accounts avoid income taxes and estate taxes. This is important. Actually, just this past week, I've been working with someone who wants to set up an endowed scholarship through his estate plans, and he initially wanted to fund it using a bequest through his will, but he elected to actually name us beneficiary of one of his IRAs. The advantage there is that we do not pay an income tax when we receive it because we're a non-for-profit. So anyone that you name as a beneficiary, IRAs, your 401ks, so if they're a human, they will pay an income tax. The IRS definitely wants its money, but not when it goes to charity. So we have I would say next to bequest, beneficiary designations of IRAs are probably the second most popular gift that we get to support. And of course, making gifts through your estate plans, what we call legacy gifts, they lend themselves quite eloquently to setting up endowments, which are permanent funds that are invested for growth and once a year have a distribution, many cases to support scholarships, but it doesn't have to be. It could be to support research, travel funds, support our athletic departments, and whatever you're passionate about, capital projects. And so legacy gifts, again, they lend themselves very well to making these types of gifts that are important. And finally, when you do make a legacy gift, you become members of our Legacy Society, which has a number of different activities. In fact, I'll put a plug in for this Friday. We have a tea happening at the Chancellor's home this Friday, but we have different activities throughout the year and different newsletters, what have you. And of course, gifts that are made via estate plans through legacy gifts count towards membership in the Jefferson Club, which has its own stewardship activities and newsletters and ways of getting involved. So something to think about as well. So I will, of course, there's probably lots of questions. I'm going to add Jen, who was fielding the questions. Hopefully you can hear us, Jen.
Yeah, we had a couple questions, Arno.
Okay, terrific.
First one, can I name a power of attorney in my will?
Very good question. And the answer is no. It's a good question. We've had that before because the power of attorney, essentially their role is to take care of things while you're alive and aren't unable to do so. So you would not be able to do that. It wouldn't be able to go into effect because the will kicks in once you've passed away.
Thank you. And the next question is, the last one we had was, can I have a friend as my executor, or does it have to be a family member?
Okay, very good question. No, it is not required that it be a relative, and there may be some instances where it may make sense to do so, but no, it does not. It can be a close friend. Again, when we think about those qualities of what you want to look for in an executor, someone who's responsible, who can do a certain amount of paperwork, and someone who's very good at that, and the probate offices will help you through the executor through that process. But yeah, someone who's very organized and who knows you well is what you're looking for. And it some instances it may be a relative, but does not have to be. Well, if you have other questions, sometimes questions come up after these presentations. Um, Please do not hesitate to reach out. We are all of us combined, I don't know, all the years of experience when it comes to legacy gift planning. Our fearless leader, Ann Morgan, who herself was an estate planning attorney in some point in her career. Uh, Jen, who has been in higher ed and higher ed fundraising for a number of years, myself, and then Cheryl. We are here to assist. And it doesn't matter where you are, we're here to help and answer your questions. And again, the fact that you're considering or exploring or dipping your toe into this is the first and the most important step. And we're here to help in any way that we can. And if we can't help you, we can certainly point you in the right direction. So we are on the website, but here's our contact information. This presentation has been recorded. So if you wish to see it again, we're happy that it should be available as well. So we thank you for your time and your interest, of course, MIZ, as I like to say, and be well. And thanks again for joining us.